So we're on for episode number 3, which is actually chapter number 3 of that reading, which was called An Essay on Trial by Jury. So if you want to catch on, just scroll back up in the channel, get episode number 1 and 2. So enough of me, let's get down into it right away before I start ranting some more. So, Chapter 3 Additional Proof of the Right and Duty of Juror. If any evidence extraneous to the history and language of Magna Carta were needed to prove that, by that chapter which guaranteed a trial by jury, all was meant that has now been ascribed to it, and that the legislation of the king was to be of no authority with the jury beyond what they choose to allow to it. Let me read that to you again. And that the legislation of the king was to be of no authority with the jury beyond what they choose to allow to it, and that the jury were to limit the punishment to be inflicted. We should find that evidence in various sources, such as the law, custom, and the character of their ancestor on the continent and of the northern European generally, in the legislation and custom that immediately succeeded Magna Carta, in the oath that have at different time been administered by juror. This evidence can be exhibited here but partially. To give it all would require too much space and labor. Section 1. Weakness of the regal authority. Huge. In his preface to the translation of Horne's Mirror of Justice, a book written in the time of Edward I in 1272 or 1272 to 1307, given a concise view of the law of England, generally says, although in the Saxons' time I find the usual word of the act to have been edicted, that's actually Latin. I can't read it. It's not real clear in the book. Constitutio, or status, little mention being made of the common. Yet, I further find that, Latin, the law had force and vigor only they were not only enacted but confirmed by the approval of the community. The Mirror of Justice itself also says, Chapter 1, Section 3, in speaking of the first constitution of the ancient king, many ordinances were made by many kings until the time of the king that now is, Edward I, the which ordinance were abused or not used by many, not very current, because they were not put in writing and certainly published. Alum says, the Franks, Lombards, and Saxons seems alike to have been jealous of judicial authority and adverse to surrounding what concerned every man's private right out of the hand of his neighbor and equal. The judicial authority here spoken of was the authority of the king, who at the time united the office of both legislature and judge, and not of a separate department of government called the judiciary, like what has existed in more modern time. Hume says, the government of the German and that of all the northern nation who established themselves on the ruin of Rome was always extremely free, and those fierce people accustomed to independence and inured to arm were more guided by persuasion than authority in the submission which they paid to their prince. The military despotism which had taken place in the Roman Empire, and which, previously to the eruption of those conquerors, had sunk the genius of man and destroyed every noble principle of science and virtue, was unable to resist the vigorous effort of a free people, and Europe, as from a new epoch, rekindled her ancient spirit and shook off the base servitude to arbitrary will and authority under which she had so long labored. The free constitution then established, however, impaired by the encroachment of succeeding prince, still preserved an air of independence and legal administration, which distinguished the European nation, and if that in if that part of the globe maintained sentiment, scrolling, of liberty, honor, equity, and valor superior to the rest of mankind, it owed these advantage chiefly to the seed implanted by those generous barbarian. The Saxon, who subdue Britain as they enjoy great liberty in their own country, obstinately retain that unreadable possession in their new settlement, and they imported into this island the same principle of independence which they had inherited from their ancestor. The chieftain, for such they were, more than king or prince, who commanded them in those military expeditions, still possesses a limited authority, and as the Saxon exterminated rather than subdue the ancient inhabitant, they were indeed transplanted into a new territory, but preserve unaltered all their civil and military institutions. The language was pure Saxon, even the name of the place, which often remain, while the tongue entirely changed, were almost all affixed by the conqueror. The manner and custom were wholly German, and the same picture of a fierce and bold liberty, which is drawn by the masterly pen of Tacitus, will suit those finder of the English government. The king, so far from being invested with arbitrary power, was only considered as the first among the citizens. His authority depended more on his personal quality than on his station. He was even so far on a level with the people that stated price was fixed for his head, and a legal fine was levied upon his murderer, which, though proportionate to his station and superior to that paid for the life of a subject, was sensible mark of his subordination to the community. Stuart says, the Saxon brought along with them into Britain their own custom, language, and civil institution. Free in Germany, they renounced not their independence when they had conquered. Proud from victory, and with their word in their hands, would they surrender their liberty to a private man? Would temporary leader, limited in their power and unprovided in resource, even think to usurp an authority over warrior who considered themselves as their equal, were impatient of control, and attached with devoted zeal to their privilege? Or would they find leisure to form resolution or opportunity to put them in practice amidst the tumult and confusion of those fierce and bloody wars, which their nation first waged with the Briton, and then engaged in among themselves? Sufficiently flatter in leading the army of their countrymen, the ambition of commander could as little suggest such design as the liberty of the people could submit to them. The conqueror of Britain retained their independence, and this island saw itself again in that free state in which the Roman arm had discovered it. The same firmness of character and generosity of manner which, in general, distinguished the German, were possessed in an eminent degree by the Saxon, and while we endeavor to unfold their political institution, we must perpetually turn our observation to that masterly picture in which the Roman historian has described these nations. In the woods of Germany shall we find the principle which directed the state of land in the different kingdom of Europe, and there shall we find the foundation of those ranks of men and those civil arrangements which the barbarian everywhere established, and which the English alone have had the good fortune or spirit to preserve. king they respected as the first magistrate of the state, but the authority possessed by them was narrow and limited. Did he, the king, at any time relax his activity and martial ardor? Did he employ his ability to the prejudice of his nation, or fancy he was superior to the law? The same power which raised him to honor, humbled and degraded him. The custom and counsel of his country pointed out to him his duty, and if he infringed on the former or disobeyed the latter, a fierce people set aside his authority. His long hair was the only ornament he affected, and to be foremost to attack an enemy was his chief distinction. Engaged in every hazardous expedition, he was a stranger to repose, and, rivaled by half the hero of his tribe, he could obtain little power. Anxious and watchful for public interest, he felt every moment his dependence and gave proof of his submission. He attended the General Assembly of his nation and was allowed the privilege to harangue it first. But the art of persuasion, though known and respected by a rude people, were unequally opposed to the prejudice and passion of man. The authority of a Saxon monarch was not more considerable. The Saxons submitted not to the arbitrary rule of prince. They administered an oath to their sovereign, which bound them to acknowledge the law and defend the right of the church and people, and if they forgot this obligation, they forfeited their offices. In both countries, a price was affixed on king, a fine expiated their murder, as well as that of the meanest citizen, and the smallest violation of ancient usage, or the least step toward tyranny, was always dangerous and often fatal to them. They were not allowed to impose taxes on the kingdom. Should I read that? Yeah, I'll read that again. They were not allowed to impose taxes on the kingdom. That's what it is. I'm not supposed to make any freaking comments. Like the German monarch, they deliberated in the General Assembly of the nation, but their legislative authority was not much respected, and their assent was considered in no better light than as a form. This, however, was their chief prerogative, and they employed it to acquire an ascendant in the state. To art and insinuation they turn as their only resource, and flatter a people whom they could not awe. But address and the ability to persuade were a weak compensation for the absence of real power. They declare war, it is said, and made peace. In both cases, however, they acted as the instrument of the state, and put in execution the resolution which his council has decreed. If, indeed, an enemy had invaded the kingdom, and its glory and its safety were concerned, the great lord took the field at the call of their sovereign. But had a sovereign declare war against a neighboring state without requiring their advice, or if he meant to revenge by arm an insult offered to him by a subject, a haughty and independent nobility refused their assistance. These they consider as the quarrel of the king and not of the nation, and in all such emergency he could only be assisted by his retainer and dependent. Nor must we imagine that the Saxon, any more than the German monarchs, succeed each other in a linear descent, or that they disposed of the crown at their pleasure. In both countries, the free election of the people filled the throne, and their choice was the only rule by which prince reigned. The succession, accordingly, of their king was often broken and interrupted, and their depositions were frequent and groundless. The will of a prince whom they had long respected, and the favor they naturally transferred to his descendant, made them often advance him to the royal dignity, but the crown of his ancestor he considered as the gift of the people, and neither expected nor claimed it as a right. In Germany, it was the business of the great to command in war, and in peace they distributed justice. The princes in Germany were earls in England. The great contended in both country in the number of their retainer and in that splendor and magnificence which are so alluring to a rude people, and though they joined to set bound to regal power, they were often animated against each other with the fiercest hatred. To a proud and impatient nobility it seems little and unreadable, really, to give or accept composition of the injury they committed or received, and their vassal, adopting their resentment and passion, war and bloodshed alone could terminate their quarrel. What necessarily resulted from this situation in society was continued as a privilege, and the great in both countries made war of their own private authority on their enemy. The Saxon earls even carried their arm against their sovereign, and surrounded with retainer or secure in fortress and castle, they despised their resentment and defied their power. The judge of the people, they presided in both countries in courts of law. The particular district over which they exerted their authority were marked out in Germany by the council of the state, and in England their jurisdiction extended over the fief and other territory they possessed. All cause, both civil and criminal, were tried before them, and they judged, except in case of the utmost importance, without appeal. They were even allowed to grant pardon to criminal and to correct by their clemency the rigor of justice, nor did the sovereign exercise any authority in their land. In these his officer formed no court, and his writ was disregarded. They had officer as well as the king, who collected their revenue and added to their greatness, and the inhabitant of their land they distinguished by the name of subject. But to attend the general assembly of their nation was the chief prerogative of the German and Saxon prince, and as they consult the interest of their country and deliberated the concerning matter of state, so in the king's court, of which also they were member, they assisted to pronounce judgment in the complaints and appeal which were lodged in it. Henry says, nothing can be more evident than this important truth, that our Anglo-Saxon king were not absolute monarch, but that their power and prerogative were limited by law and custom of the country. Our Saxon ancestor had been governed by limited monarch in their native scats of the continent, and there is not the least appearance or probability that they relinquished their liberty and submitted to absolute government in their new settlement in this island. It is not to be imagined that man, whose reigning passion was the love of liberty, would willingly resign it, and their new sovereign, who had been their fellow soldier, had certainly no power to compel them to such a resignation. Mackintosh says, the Saxon chief, who were called king, originally acquired by the same natural cause which have gradually and everywhere raised a few men above their fellow. They were, doubtless, more experienced, more skillful, more brave, and more beautiful than those who followed them. A king was powerful in war by the luster of his arm and the obvious necessity of obedience. His influence in peace fluctuated with his personal character. In the progress of usage, his power became more fixed and more limited. It would be very unreasonable to suppose that the northern German who had conquered England had so far changed their characteristic habit from the age of Tacitus that the victor became slave, and that their general were converted into tyrant. Writen, in his discourse on the origin of nature and the English Constitution, says, "There are but two things the Saxons did not think proper to entrust their king with, for being of like passion with other men, they might very possibly abuse them, namely the power of changing the law enacted by consent of king and people, and the power of raising tax at pleasure. From these two articles sprung numberless branches concerning the liberty and property of the subject, which the king can not touch without breaking the constitution, and they are the distinguishing character of the English monarchy. The prerogative of the crown and the right and privilege of the people, flowing from the two forementioned articles, are the ground of all law that from time to time had been made by unanimous consent of the king and people. The English government consisted in the strict union of the king's prerogative with the people's liberty. But when king arose, as some there were, that aim at absolute power by changing the old and making new law at pleasure, by imposing illegal taxes on the people, this excellent government being in a manner dissolved by these destructive measures, confusion and civil war ensued, which some very wrongfully ascribe as fickle and restless temper of the English." Rapin's preface on his History of England. Hallam says that among the Saxons the royal authority was weak, but although the king himself had so little authority that it cannot be supposed for a moment that his law were regarded as imperative by the people, it has nevertheless been claimed in modern time by some who seem determined to find or make a precedent for the present legislative authority of Parliament, that his law were authoritative when assented to by the Writen, or whatever that means, probably is German. If it's not, well, my bad. Or assembly of wise men, that is, the bishops and barons. But this assembly evidently had no legislative power whatever. The king would occasionally invite the bishops and barons to meet him for consultation on public affairs, simply as a council and not as a legislative body. Such as saw fit to attend did so. If they were agree upon what ought to be done, the king would pass a law accordingly, and the barons and bishop would then return and inform the people orally what law had been passed, and use their influence with them to induce them to conform to the law of the king and the recommendation of the council. And the people, no doubt, were much likely to accept a law of the king if it had been approved by this council than if it had not. But it was still only a law of the king, which they obeyed or disregarded according to their own notion of expediency. The number who usually attended this council were too small to admit of the supposition that they had any legislative authority whatever to impose law on the people against their will. Lingard says, "It was necessary that the king should obtain the assent of the member of the Writen to all legislative enactments, because without their acquiescence and support it was impossible to carry them into execution. Too many charter law we have the signature of the Written. They seldom exceed 30 in number. They never amounted to 60. It is ridiculous to suppose that the assents of such an assembly gave any authority to the law of the king, or had any influence in securing obedience to them otherwise than by way of persuasion. If this body had any real legislative authority, such as is accorded to the legislative body of the present day, they would have made themselves at once the most conspicuous portion of the government, and would have left behind them abundant evidence of their power. Instead, the evidence simply of their assent to a few laws passed by the king. More than this, if this body had any real legislative authority, they would have constituted an aristocracy having its conjunction with the king absolute power over the people, assembling voluntarily merely on the invitation of the king, deputed by nobody but themselves, representing nobody but themselves, responsible to nobody but themselves. Their legislative authority, if they had any, would of necessity have made the government of an aristocracy merely, and the people slave of course. And this would necessarily have been the picture that history would have given us of the Anglo-Saxon government and of the Anglo-Saxon liberty. The fact that the people had no representation in this assembly, and the further fact that through their juries alone, they nevertheless maintained that noble freedom, the very tradition of which, after the substance of the thing itself had ceased to exist, has constituted the greatest pride and glory of the nation to this day, prove that this assembly exercised no authority which jury of the people acknowledge except at their own discretion. There is not a more palpable truth in the history of the Anglo-Saxon government than that stated in the introduction of Gilbert's History of the Common Pleas, that the county and hundred court, to which should have been added the other court in which juries sat, the court baron and the court leet, in those time were the real and only parliament of the kingdom. And why were they the real and only parliament of the kingdom? Solely because, as will be hereafter shown, the jury in those courts tried cause on their intrinsic merit according to their own idea of justice, irrespective of the law agreed upon by king, priest, and barons, and whatever principle they uniformly or perhaps generally enforce, and none other, become practically the law of the land as matter of course. Finally, on this point, conclusive proof that the legislation of the king was of little or no authority is found in the fact that the king enacted so few laws. In their law, and if their law had been received as authoritative in the manner that legislative enactment are at this day, they would have been making law continually. Yet the code of the most celebrated king are very small, and were little more than compilation of immemorial custom. The code of Alfred would not fill 12 pages of status book of Massachusetts, and was little or nothing else than a compilation of the law of Moses and the Saxon custom, evidently collected from consideration of convenience rather than enacted on the principle of authority. The code of Edward the Confessor would not fill 20 pages of the status book of Massachusetts, and says Blackstone, seemed to have been no more than a new edition or fresh promulgation of Alfred's Code or Dome Book, which with such addition and improvement as the experience of a century and a half suggested. I'll scroll slowly and pause briefly so you can read the small print at the bottom or the notes. Half this page is small print, just like in contract law. Anyway, no comments. I'm free to do comments. The Code of William the Conqueror would fill less than 7 pages of the status book of Massachusetts, and most of the law contained in it are taken from the law of the preceding king, and especially of Edward the Confessor, whose law William swore to observe, but few of his own being added. The code of the other Saxon and Norman king were, as a general rule, less voluminous even than these that have been named, and probably did not exceed them in originality. The Norman prince, from William the Conqueror to John, I think without exception, bound himself, and in order to maintain their throne, were obliged to bind themselves to observe the ancient law and custom. In other words, the lex terra or common law of the kingdom. Even Magna Carta contained hardly anything under this same common law, with some new security for its observance. Scrolling. How this abstinence from legislation on part of ancient king to be accounted for, except on the supposition that the people would accept and jury enforce few or no new law enacted by their king. Plainly, it can be accounted for in no other way. In fact, all history informs us that anciently the attempt of the king to introduce or establish new law met with determined resistance from the people and generally resulted in failure. We will that the law of England be not changed was a determined principle with the Anglo-Saxon, from which they seldom departed up to the time of Magna Carta, and indeed until long after. Section 2 or 4, I can't read clearly. The ancient common law jury were mere court of consciences. But it is in the administration of justice or of law that the freedom or subjection of a people is tested. If this administration be in accordance with the arbitrary will of the legislature, that is, if his will, as it appears in his status, be the highest rule of decision known to the judicial tribunal, the government is a despotism and the people are slave. If, on the other hand, the rule of decision be those principles of natural equity and justice which constitute, or at least are embodied in, the general conscience of mankind, the people are free in just so far as their conscience is unlightened. That the authority of the king was of little weight with the judicial tribunal must necessarily be inferred from the fact already stated, that his authority over the people was but weak. If the authority of his law had been paramount in judicial tribunals, it would have been paramount with the people, of course, because they would have had no alternative but submission. The fact, then, that his law were not authoritative with the people is proof that they were not authoritative with the tribunal. In other words, that they were not, as matter of course, enforced by the tribunals. But we have additional evidence that up to the time of Magna Carta, the law of the king were not binding upon the judicial tribunal, and if they were not binding before that time, they certainly were not afterward, as already been shown from Magna Carta itself. It is manifest from all the account we have of the court in which juries sat prior to Magna Carta, such as the court baron, the hundred court, the court leet, and the county court, that they were mere courts of conscience, and that the jury were the judge deciding cause according to their own notion of equity, and not according to any law of the king unless they thought them just. These courts, it must be considered, were very numerous and held very frequent session. There were probably 7, 8, or 900 court a month in the kingdom, the object being, as Blackstone says, to bring justice home to every man's door. The number of the county courts, of course, corresponded to the number of county, 36. The court leet was the criminal court for a district, less a county. The 100 court was the court for one of those districts anciently called a 100, because at the time of their first organization for judicial purpose, they comprised but 100 family. The court baron was the court for a single manor, and there was a court for every manor in the kingdom. All these courts were holden as often as once in 3 or 5 weeks, the county court once a month. The king's judge were present at none of these courts, the only officer in attendance being sheriff, bailiff, and steward, merely ministerial and not judicial officer, doubtless incompetent, and, if not incompetent, untrustworthy for giving the jury any reliable information in matter of law, beyond what was already known to the juror themselves. And yet these were the court in which was done all the judicial business, both civil and criminal, of the nation, except appeal and some of the more important difficult case. It is plain that the jury in these courts must, of necessity, have been the sole judge of all matter of law whatsoever, because there was no one present but sheriff, bailiff, and steward to give them any instruction, and surely it will not be pretended that the juror were bound to take their law from such sorts as these. In the second place, it is manifest that the principle of law by which the jury determined causes were, as a general rule, nothing else than their own idea of natural equity, and not any law of the king, because but few laws were enacted, and many of those were not written, but only agreed upon his council. Of those that were written, few copy only were made, printing being then unknown, and not enough to supply all or any considerable number of these numerous courts. Beside and beyond all this, few or none of the juror could have read the law if they had been written, because few or none of the common people could at the time read. Not only were common people unable to read their own language, but at the time of Magna Carta, the law were written in Latin, a language that could be read by few people except the priests, who were also the lawyers of the nation. Mackintosh says the first act of the House of Commons, composed and recorded in English tongue, was in 1115. 2 centuries, it must be 1415, 2 centuries after Magna Carta. Up to this time, and for some 70 years later, the law were generally written, either in Latin or French, both language incapable of being read by the common people, as well Normans as Saxon, and one of them, the Latin, not only incapable of being read by them, but of being even understood when it was earthed by them. To suppose that the people were bound to obey and jury to enforce law, many of which were unwritten, none of which they could read, and the larger part of which, those written in Latin, they could not translate or understand when they heard them read, is equivalent to supposing the nation sunk in the most degrading slavery instead of enjoying a liberty of their own choosing. Their knowledge of the law passed by the king was, of course, derived only from oral information, and the good law, as some of them were called, in contradistinction to other, those which the people at large esteemed to be good law, were doubtless informed by the jury, and the other as a general thing disregarded. That such was the nature of judicial proceeding and of the power of jury up to the time of Magna Carta is further shown by the following authorities. The sheriff and bailiff cause their free tenant of their bailiwicks to meet at their county and hundreds, at which justice was done, that every one so judge his neighbor by such judgment as a man could not themselves receive in the like case, until such time as the custom of the realm were put in writing and certainly published. And although a free man commonly was not to serve as a judge or juror, without his assent, nevertheless it was ascended unto that free tenant should meet together in the county and hundreds and Lord's court, if they were not specially exempted to do such suit, and there judge their neighbor. Gilbert, in his treatise on the Constitution of England, says, in the county court, if the debt was above 40 shilling, they issue a justice, a commission, to the sheriff to enable him to hold such a plea where the suitor or juror are judge of the law and fact. Gilbert's case in Law and Equity, whatever. All the ancient writs given in Glanville for summoning juror indicate that the juror judge of everything on their conscience only. The writs are in this form: summon 12 free and legal men, or sometime 12 knights, to be in court, prepare upon their oath to declare whether A or B have been the greater right of to the land or other thing in question. Crabbe, speaking of the time of Henry I, 1100 to 1135, recognized the fact that the juror were the judge. He says, by one law, everyone was to be tried by his peer who were of the same neighborhood as himself. By another law, the judge, for so the jury were called, were both to be chosen by the party impleaded after the manner of the Danish numbas, by which probably it is understood that the defendant had the liberty of taking exception to or challenge the jury, as it was afterward called. Reeves says, the great court for civil business was the county court, held once every 4 weeks. Here the sheriff presided, but the suitor of the court, as they were called, that is, the freeman or landholder of the country, were the judge, and the sheriff was to execute the judgment. The 100th court was held before some bailiff, the leet before the lord of the manor's steward. Out of the county court was derived an inferior court of civil jurisdiction called the court baron. This was held from 3 weeks to 3 weeks, and it was in every respect like the county court. That is, the juror were judge in it, only the lord to whom this franchise was granted, or his steward, preside instead of the sheriff. Reeves' History of the English Law. Chief Baron Gilbert says, beside the tenant of the king, which held per baroniam by the right of a baron, and did suit and service, serves as judge at his own court, and the burgher and tenant in his ancient demesne, that did suit and service, serve as juror or judge in their own court in person, and in the king's by proxy. There was also a set of freeholder that did suit and service, serve as juror at the county court. These were such as anciently held of the lord of the county, and by the escheats of earldom had fallen to the king, or such were granted out by service to all of the king, but with particular reservation to do suits and service, or serve as juror, before the king's bailiff, because it was necessary the sheriff or bailiff of the king should have juror at the county court, that the business might be dispatched. These suitor are the par or peer of the county court, and indeed the judge of it, as peers were the judge in every court baron. And therefore the king's bailiff, having a court before him, there must be par or judge, for the sheriff himself is not a judge, and though the style of the court is curia prima comitatus, Latin, first court of the county, E.C. Knight Sheriff of the aforesaid county, held at B. By which it appeared that the court was the sheriff's, yet by the old feudal constitution the lord was not a judge, but the peers only, so that even in justices, whatever, which was a commission to the sheriff to hold plea of more than was allowed by the natural jurisdiction of a county court, the peers or juror only were judge, and not the sheriff, because it was to hold plea in the same manner that they used to do in that the Lord's Court. Gilbert on Courts of the Exchequer, chapter 5, page 61-62. It is a distinguished feature of the feudal system to make civil jurisdiction necessarily and criminal jurisdiction ordinarily coexistence with tenure, and according there is inseparably incident to every manor of a court's baron, being a court in which the freeholder of the manor are the sole judge, but in which the lord by himself, or more commonly by his steward, presides. The same work, speaking of the county court, says the judge were the freeholder who did suit to the court. See word courts. In the case of freeholder attending as suitor, the county court or court baron, as in the case of the ancient tenant per baronium attending parliament, the suitor are the judge of the court, both for law and for fact, and the sheriff or under the sheriff in the county court, and the lord of or his steward in the court baron are only presiding officer with no judicial authority. Courts: the space enclosed by the wall of a feudal residence, in which the follower of a lord used to assemble in the Middle Age to administer justice and decide respecting affairs of the common interest. It was next used for those who stood in immediate connection with the lord and master, the peer of the court, the limited portion of the General Assembly to which was entrusted the pronouncing of judgment. In courts baron or county court, the steward was not judge, but the peers, nor was the speaker in the House of Lords judge, but the barons only. Crabbe, speaking of the Saxon time, says, the sheriff presided at the 100 court, and sometimes sat in the place of the earl in the county court. The sheriff afterward became the sole presiding officer of the county court. Sir Thomas Smith, Secretary of State of Queen Elizabeth, writing more than 300 years after Magna Carta, in describing the difference between the civil law and the English law, says, Judex is of us called judge, but our fashion is so diverse that they which give the deadly stroke, and either condemn or acquit the man for guilty or not guilty, are not called judge, but the 12 men, and the same order as well in civil matter and pecuniary as in matter criminal. Smith's Commonwealth of England, chapter 9, page 53, edition of 1621. Court leet, that the leet is the most ancient court in the land for criminal matter, the court baron being of no less antiquity and civil, had been pronounced by the highest legal authority. Lord Mansfield states that this court was co-equal with the establishment of the Saxon ear, and its activity mark were visibly among the Saxon and Dane. The leet is a court of record for the cognizance of criminal matter or plea of the crown, and necessarily belong to the king, though a subject, usually the lord of the manor, may be, and it is entitled to the profit, consisting of the essoing pains, fine, and amercement. Holy shit, that old English is hard. It is held before the steward, or was, in ancient time, before the bailiff of the lord. Tomlin's Law Dictionary word count courtly. Of course, the jury were the judge in this court, where only a steward or bailiff of a manor preside. No causes of consequence was determined without the king's writs, for even in the county court of the debt, which were above 40 shilling, there issued a justice or commission to the sheriff to enable to hold such plea, where the suitor are judge of the law and facts. Disposition, that the matter of law was decided by the king's justice, but the matter of fact by the pairs or peers, is wholly incompatible with common law, for the jurata or jury were the sole judge both of the law and the facts. We come now to the challenge, and of old the suitor in court who were judge could not be challenged, nor by the feudal law could the pars or peers be even challenged. Latin. The peers who have ordinary jurisdiction cannot be rejected, but those suitor who are judge of the court could not be challenged, and the reason is that there are several qualifications required by the writs, that they be liberos, a legal Latin, free and legal men of the neighborhood of the place laid in the declaration. To the question of law, the juror do not answer. A notice says that this is indeed a maxim in civil law jurisprudence, but it does not bind an English jury, for by the common law of the land, the jury are judge as well of the matter of law as of the facts. And with this difference only, that a Saxon word, that or judge on the bench is to give them no assistance in determining of facts, but if there have any doubt among themselves relating to the matter of law, they may then request him to explain it to them, which when he at bat done, and they are thus becoming well informed, they only become competent judge of the matter of law, and this is the province of the judge on the bench, namely to show or teach the law, but not to take upon him the trial of the delinquent, either in matter of fact or in matter of law. Here various Saxon law are quoted. In neither of these fundamental law is there the least word, hint, or idea that the earl or alderman, that is to say, the presiding officer of the court, which is tantamount to the judge on the bench, is to take upon him to judge the delinquent in any sense whatever. The sole purpose of his office is to teach the secular or worldly law. The administration of justice was carefully provided for, and it was not the caprice of their lord, but the sentence of their peer that they obeyed. Each was the judge of his equal, and each by his equal was judge. Alum says, a respectable class of free socager, having in general full right of alienating their land, and holding them probably at a small certain rent from the lord of the manor, frequently occur in Domesday Book. Sounds like Doomsday Book, anyway. They undoubtedly were suitor of the court's baron of the lord, to whose sock or right of justice they belong. They were consequently judged in civil cause determined before the manorial tribunal. Stephen adopt as correct the following quotation from Blackstone. The court baron is a court incident to every manor in the kingdom to be holden by the steward within the same said manor. It is a court of common law, and it is the court before the freeholder who owe suits and service to the manor are bound to serve as juror in the court of the manor, the steward being rather the registrar than the judge. The freeholders' court was composed of the lord's tenants who were the equal of each other and were bound by the feudal tenure to assist their lord in the dispensation of domestic justice. This was formerly held every 3 weeks, and its most important business was to determine by writs of rights all controversy relating to the right of the land within the manor. 100 court is only a larger courts baron, being held for all the inhabitants of a particular hundred instead of a manor. The free suitor or juror are here also the judge, and the steward the registrar or register. The county court is a court incident to the jurisdiction of the sheriff. The freeholder of the county are real judge in this court, and the sheriff is the ministerial officer. Blackstone described these courts as court wherein injuries were redressed in an easy and expeditious manner by the suffrage of neighbor and friends. When we read of a certain number of freemen chosen by the party to decide in a dispute, all bound by oath to vote in foro conscientia, in Latin, and that their decision, not the will of the judge presiding, ended the suit, were at once perceived that a great improvement had been made in the old form of compurgation, an improvement which impartial observation can have no hesitation to pronounce as identical in its free and in its main feature within the trial by jury. The bishops and the earls, or in his absence the sheriff, and sometimes both the earl and sheriff, presided at county court. The sheriff usually alone presided at the meeting or court of the hundred. In the city and town which were not within any particular jurisdiction, there was held at regular stated interval a borough court for the administration of justice, at which a sheriff or magistrate appointed by the king presided. The right of the plaintiff and defendant and of prosecutor and criminal to challenge the judge or assessor appointed to try the cause in civil manner and to decide upon the guilt or innocence of the accused in criminal manner is recognized in the treatise called the Law of Henry I, but I cannot discover from the Anglo-Saxon law or history that before the conquest the party had any general rights of challenge. Indeed, had such right existed, the injunction to all persons standing in the situation of judge to do right according to their conscience would scarcely have been so frequently and anxiously repeated. Ali says, the administration of the common justice of the kingdom seems to be wholly dispensed in the county court, hundred courts, and courts baron, except some of the greater crime reformed by the law of King Henry I, and that part thereof which was sometime taken by the Latin. This doubtless bred great inconvenience, uncertainty, and variety in the law. First, by the ignorance of the judge, which were the freeholder of the county. Thirdly, a third inconvenience was that all the business of any moment was carried by parties and faction, for freeholder being generally the judge, and conversing one among another, and being as it were the chief judge, not only of the fact but of the law. Every man that had a suit there sped accordingly as he could make party. In all these tribunal, county court, hundred courts, the judge were the free tenant owing suit to the court and afterward call its peer. Henry calls the 12 juror assessor and says these assessor, who were in reality judge, took a solemn oath that they would faithfully discharge the duty of their office and not suffer an innocent man to be condemned nor any guilty person to be acquitted. Tyrrell says, Alfred Canton in his kingdom, first into trying and lattice, as they are still called in Kent and other places, consisted of 300 or 400, in which the freeholder being judge, such cause were brought as could not be determined in the 100 courts. Of the 100 courts, he says, in this court anciently one of the principal inhabitants called the alderman, together with the barons of the 100, id s the freeholder was judge. Also he says, by a law of Edward the Elder, every sheriff shall convene the people once a month and do equal right to all, putting an end to controversy at time appointed. A status emphatically termed the grand assize enable the defendant, and if he thought proper, to abide by the testimony of the 12 good and lawful knights, chosen by 4 other of the vicinage, and whose oath gave a final decision to the contested claim. For the moment when the crown became accustomed to the inquest, a restraint was imposed upon every branch of the prerogative. The king could never be informed of his right, but through the medium of the people. Every extent by which he claimed the profit and advantages resulting from the casualty of tenor, every process by which he repressed the usurpation of the baronage, depend upon the good men and true who were impaneled to pass between the subject and the sovereign, and the thunder of the exchequer at Westminster might be silenced by the honesty, the firmness, or the obstinacy of one sturdy knight or yeoman in the distant shire. Taxation was controlled in the same manner by voice of those who were most liable to oppression. A jury was impaneled to adjudge the proportion due to the sovereign, and this course was not essentially varied, even after the right of granting aids to the crown was fully acknowledged to be vested in the parliament of the realm. The people taxed themselves, and the collection of the grant was checked and controlled, and perhaps in many instances evaded by these virtual representatives of the community. The principle of the jury, therefore, not confined to its mere application as a mode of trying contested fact, whether in criminal or in civil or criminal case, and both in its form and its consequences, it had very material influence upon the general constitution of the realm. The mainspring of the machinery of remedial justice existed in the franchise of the lower and the lowest order of the political hierarchy. Without the suffrage of the yeoman, the burgess, and the churl, the sovereign could not exercise the most important and most essential function of royalty. From them he received the power of life and death. He could not yield or wield the swords of justice until the humblest of his subjects placed the weapon in his hands. Coke says, the court of the county is no court of record, and the suitor are the judge thereof. Also, the court of the 100 is no court of record, and the suitor be therefore judge. Also, the court baron is a court incident to every manner, and is not of record, and the suitor be therefore judge. Also, the court of ancient dismene is in the nature of a court baron, wherein the suitor are judge, and is no court of record. Miller says, some author have thought that jurymen were originally compurgator, it's hard to read, call by a defendant to swear that they believe him innocent of the fact with which he was charged. But compurgator were merely witnesses. Jurymen were in reality judges. The former were called to confirm the oath of the party by swearing according to their belief that he had told the truth in his oath of purgation. The latter were appointed to try by witnesses and by all other means of proof whether he was innocent or guilty. Jury were accustomed to ascertain the truth of fact by the defendant's oath of purgation, together with that of compurgator. Both of them, jurymen and compurgator, were obliged to swear that they would tell the truth. According to the simple idea of our forefather, guilt or innocence was regarded as a mere matter of fact, and it was thought that no man who knew the real circumstance of a case could be at a loss to determine whether the culprit ought to be condemned or acquitted. Also, the same form of proceeding which took place in the administration of justice among the vassals of a barony was gradually extended to the court held in trading town. Also, the same regulation concerning the distribution of justice by the intervention of jury were introduced into the baron's court of the king as into those of the nobility, or such of his subject as retain their allodial property. Also, this tribunal, can't read here, or king's court, afterward divided into the court of king, bench, common plea, and exchequer, was properly the ordinary baron court of the king, and being in the same circumstance with the baron's court of the nobility, it was under the same necessity of trying cause by the intervention of a jury. Speaking of the time of Edward I, 1272 to 1307, Miller says, what is called the petty jury was therefore introduced into this tribunal, as well as into the auxiliary court employed to distribute justice in the circus, and was thus rendered essentially necessary in determining cause of every sort, whether civil, criminal, or fiscal. Also, that this form of trial by jury obtained universally in all the feudal government, as well as in that of England, there can be no reason to doubt. In France, in Germany, and in other European countries where we have any account of the constitution and procedure of the feudal court, it appears that lawsuits of every sort concerning the free man or vassal of a barony were determined by the peer of the court, and that the judge took little more upon him than regulate the method of proceeding or declare the verdict of the jury. Also, among the Gothic nation of modern Europe, the custom of deciding lawsuit by a jury seemed to have prevailed universally, first in the allodial court of the county or of the hundred, and afterward in the baron's court of every feudal superior. Palgrave says that in Germany the Graf or sheriff placed himself in the seat of judgment and gave the charge to the assembled free echevins, warning them to pronounce judgment according to right and justice. Also that in Germany the echevins were composed of the villeinage, somewhat obscured in their function by learning of the grave civilian who was associated to them, and somewhat limited by the encroachment of modern feudality, but they were still substantially the judge of the court. Palgraves also says, Scotland, in like manner, had the law of burlaw or burlaw, which were made and determined by the neighbor elected by common consent in the burla courts, wherein knowledge was taken of complaints between neighbor and neighbors, which men, so chosen, were judge and arbitrator, and called burla man. That sounds funny. But in order to understand the common law trial by jury as it existed prior to Magna Carta, and as it was guaranteed by that instrument, it is perhaps indispensable to understand more fully the nature of the court in which jury sat, and the extent of the power exercised by jury in those courts. I therefore give in a note extended extract on these points from Stuart on the Constitution of England and from Blackman's commentaries. So I'll scroll slowly, you can read those commentary. The commentary are longer than the text in the page. Small print. You can always pause the video if you really want to read this. That all these courts were mere courts of conscience in which the jury were sole judge, administrating justice according to their own idea of it, and no hand. It is not only shown by the extracts, more small prints. Already given, but it is explicitly acknowledged in the following ones, in which the modern court of conscience are compared to the ancient hundred and county court, and the preference, more small prints, good shit, I'm not reading it. Given to the latter on the ground that the duty of the juror in the one case and of the commissioner in the other are the same, and that the conscience of a jury are a safer and purer, more small prints. Maybe I should have read the small prints and not the main text. I'll read this little part from the small print. There was no distinction between the civil and criminal court as to the right or powers of juries. Tribunal, then the conscience of individual, especially appointed and holding permanent office. But there was one species of court constituted by Act of Parliament in the city of London and other trading and populous district, which in their proceeding so vary from the course of the common law that they deserve a more particular consideration. I mean the court of request, or courts of conscience, for the recovery of small debt. The first of these was established in London so early as the reign of Henry VIII by an act of their Common Council, which, however, was certainly insufficient for that purpose and illegal till confirmed by the status of 3 1 chapter 15, which has since been explained and amended by Status 14 Geo 2 chapter 10, the Constitution is this: 2 aldermen and 4 commoneers sit twice a week to hear all cause of debt not exceeding the value of 40 shilling, which they examine in a summary way by the oath of the party and other witnesses, and make such order therein as is consonant to equity and good conscience. Divers trading town and other district have obtained Act of Parliaments, small prints, for establishing in them court of conscience upon nearly the same plan as that in the city of London. The anxious desire that has been shown to obtain these several acts prove clearly that the nation in general is truly sensible of the great inconvenience arising from the disuse of the ancient county and hundred court, wherein cause of this small value were always formally decided with very little trouble and expenses to the party. But it is to be feared that the general remedy which of the late hath been principally applied to this inconvenient, the erecting of these new jurisdiction, may itself be attended in time with very ill consequences, as the method of proceeding therein is entirely in derogation of the common law, and their large discretionary power create a petty tyranny in a set of standing commissioner, and as the disuse of the trial by jury may tend to estrange the mind of the people from that valuable prerogative of Englishmen, which has already been more than sufficiently excluded in many instances. How much rather it is to be wished that the proceeding in the county, and under courts could be again, small prints, revive without burdening the freeholder with too frequent and tedious attendances, and at the same time removing the delay that have insensibly erupt into their proceeding, and the power that either party has of transferring at pleasure their suit to the court at Westminster. And we may with satisfaction observe that this experiment has been actually tried and has succeeded in a populous county of Middlesex, which might serve as an example for other. 1. That a special county court shall be held at least once in a month in every hundred of the county of Middlesex. 2. That 12 freeholder of that hundred qualified to serve on jury and struck by the sheriff shall be summoned to appear at such court by rotation, so as none shall be summoned oftener than once a year. That in all cause, or 3, that in all cause not exceeding the value of 40 shilling, the county clerk and 12 suitors shall proceed in a summary way, examining the party and witness on oath, without the formal process anciently used, and shall make such order therein as they shall judge agreeable to conscience. What are these but court of conscience? And yet Blackstone tells us that a revival of the ancient hundred and county court. And what does this fact prove but that the ancient common law court in which juries sat were mere court of conscience? It is perfectly evident that in all these courts the juror were the judge and determined all question of law for themselves, because the only alternative to that supposition is that the juror took their law from sheriff, bailiff, and steward, of which there is not the least evidence in history, nor the least probability in reason. It is evident also that they judge independently of the law of the king, for the reason before given, that the authority of the king was held in very little esteem, and secondly, that the law of the king not being printed, and the people being unable to read them if they had been printed, must have been in a great measure unknown to them, and could have been received by them only on the authority of the sheriff, bailiff, or steward. If law were to be received by them on the authority of these officers, the latter would have imposed such law upon the people as they pleased. These courts that have now been described were continued in full power long after Magna Carta, no alteration being made in them by that instrument, nor in the mode of administrating justice in them. There is no evidence whatever, so far to us as I am aware, that jury had any less power in the court held by the king's justice than in those held by sheriff, bailiff, and steward, and there is no probability whatever that they had. All the difference between the former court and the latter undoubtedly was that in the former the jury had the benefit of advice and assistance of the justice, which would, of course, be considered valuable in difficult case on the account of the justice being regarded as more learned, not only in the law of the king, but also in the common law or law of the land. The conclusion, therefore, I think, inevitably must be that neither the law of the king nor the instruction of his justice had any authority over the juror beyond what the latter saw fit to accord to them. And this view is confirmed by the remark of Hallam, the truth of which all will acknowledge. The rule of legal decision among a rude people are always very simple, not serving much to guide, far less to control the feeling of natural equity. It is evident that it was in this way, by the free and concurrent judgment of jury, approving and enforcing certain law and rule of conduct corresponding to their notion of right and justice, that the law and custom, which for the most part made up the common law, and were called at that day the good law and good custom, and the law of the land were established. How, otherwise, could they ever have become established, as Blackstone says, they were, by long and immemorial usage, and by their universal reception throughout the kingdom, when, as the Mirror says, justice was so done that every one so judged his neighbor by such judgment as a man could not elsewhere receive in the like case until such time as the custom of the realm were put in writing and certainly published. The fact that in the Dark Age so many of the principles of natural equity, as those then embraced in the common law, should have been so uniformly recognized and enforced by jury as to have become established by general consent as the law of the land, and the further fact that this law of the land was held so sacred that even the king could not lawfully infringe or alter it, but was required to swear to maintain it, are beautiful and impressive illustration of the truth that man's mind, even in comparative infancy of other knowledge, have clear and coincidently idea of the elementary principle and the paramount obligation of justice. The same fact also proved that the common mind and the general, or perhaps rather the universal conscience, as developed in the untrammeled judgment of jury, may be safely relied upon the preservation of individual right in civil society, and that there is no necessity or excuse for that deluge of arbitrary legislation with which the present age is overwhelmed under the pretext that unless law be made, the law will not be known, and the pretext, by the way, almost universally used for overturning instead of establishing the principle of justice. All right, so because this part has been so long, I'm going to stop the recording in a few moments here. We're already recording an hour, 22 minutes. So in order for you to digest what I've just said and all of what I've said. Yeah, I'm gonna stop here and rant a little bit before I choose to read the rest of it. We've done a huge jump, probably reading 30 pages and of mainly history. But what you need to know is mainly the same thing as the prior chapter. There is only one freedom, is trial by jury, and only if this jury retains the power to void law may you have justice, and without any justice, well, there's no freedom. It's despotism or tyranny that governs by edict. They would write law that would fit them and not us. In fact, courts are supposed to be courts of conscience, not courts of law. And some people, that's the question that it brings to the table. What are law goods for? Well, in terms of people's law, do no harm is the only law that really applies. And as it comes to liberty, it's trial by jury only if jury can void the other law. Which other law? Well, whatever a parliament or representative government of the people, or even unrepresentative government of the people, whatever law they write is commercial. It is to govern corporation, enterprise, or other form of businesses. So yes, there are law for them. Yes, there need to abide by them. But you, as a human and not a person, a corporation is a person. But you, as a human, as a free man or free woman, there is only one law. It is do no harm. Otherwise, and it's willingly, by the way, do no harm by plan or by organization of other with other people. Otherwise, it may raise a claim against you in a real court of justice, where you can request at any moment a judgment of your peer, no matter how small the prejudice has been that has been claimed against you, or no matter how big. If you don't get a judgment by your peer, it is a judgment by government, and it's no better than a tyranny or despotism. I, for one, don't want to be ruled by government, that's for sure. I want to be ruled by conscience, my own first. If I do wrongfully within my thinking or conscience, then I'd like other people, equal peers and people from my neighborhood, to put me on trial if I willingly did some wrong, or knowingly did some wrong. And that's the only way that freedom can be ours. If the guarantee of our freedom is in the end of an organized group, so-called the government, but today by also private entity called corporation, it is not ours, it's theirs, and we shall not get it. We must put an end to whatever tyranny wants to be this week, because our ancestor understood it 800 years ago, and for the bulk of that time until recently. How did we forget? It's simply because we put our children into the end of into the teachings end of these bastards who don't want us to be free. They want an army of slaves just intelligent enough to fill in the paperwork and press the button, but never intelligent enough to ask any questions, especially not the one about liberty. So we must put an end to the worldwide tyranny and exploitation of other people that is done wrongfully under our name. Understand that those who pose as our leader are not our leader at all. They're a bunch of crooks and asshole, and it's not my opinion. Remember, if you've been following this channel, that and it's published on the same channel here. I was lead prosecutor at the grand jury in 2015. Just like we have learned in this book that I'm reading, I was not the judge, and I made sure that they clearly understand that I was a party to the cause that I was presenting, and they would judge the situation according to their own conscience and not according to the law, because it was the law that was put on trial, and it was rendered null and void exactly as this book is teaching us. And remember one thing, I just got this book a few weeks back, and I'm reading it with you. I've read the first 2 chapters, but this third one that I'm reading now with you, I never read it before. I didn't read it last night and say, okay, I'm gonna do the recording. No, I just decided I'm gonna do the recording, and I'm learning it as I'm reading. And so at the same time as you, well, probably because it's a recording earlier than you. But yeah, these people at the grand jury, they did exactly what our ancestor did. They were men of honor, men and women of honor. They came to that grand jury. They've learned that this law was, well, bad, I guess. I would resume it. And they voided it. And not only that they voided the assembly that has written it, and the other assembly, which is charged by the first assembly that I just named, to put it in action, to enact it. So not only did they voided the law, they voided the assembly that called himself legislature, and they voided the assembly which is charged to in charge of enacting it, so the executive. So that grand jury was wise. It was wise to do it. It done the right thing. It is still true to this day, even though that they've tried to attack me as a human, as my character. Not a word was says about that grand jury. They ignored it, and it's great like that, because it was right. It was right to convene. It was right to do so, and it was also right and not wrong. Right, that's how I'm using this word, to make such a decision the way they've done it, and to find out that those who call themselves government are no less than parrots, and they don't belong there anymore. So this way, today, after the judgment of a peer, not my opinion, I can say to these bastards posing as government at every level, even the postal office person, which, by the way, they give me a service. I respect them for that service. But as they pretend to be part of the government, I can tell them, without my opinion being involved, to go fuck yourself because you're a liar. And that's it. So the people who've been selected to run parliament and to run legislature in the province where you are watching this, they're no more legal. They have no constitutional lawful ground to stand on. They're just a bunch of corporate parrots. So once again, I can tell them to go fuck themselves. Whatever they say, whatever they think, whatever they do, whatever they pretend, that's only what it is, pretension. They cannot prove it, as for one can prove the exact opposite after a grand jury of their peers. And of my peers as well. But once again, when I showed up to that grand jury, I was a party. My mind was already made, and I wanted them, and I was yelling at them, seriously yelling in front of their face. It's all recorded. You can check it out if you speak French. To prove me wrong, to tell me, those 23 courageous people, that I'm a nut fucking case and I belong into a psychiatric ward. And they could not do that. They didn't want to do that. In fact, they yelled back at me because you give upon other what you want to be done upon you. They were yelling back by the end to get on with it, that I was so much right that they just wanted to sign the damn thing and get on with their life, and so I could be mandated to correct the situation, which is exactly what I'm doing today by reading you this and by telling you that. I've been reading for almost 4 hours now, and a few minutes of comments, or maybe the other way around, 4 hours of comments and then a few minutes of reading, just to prove you that the power is in your hand. Those bastards have none, especially none above you, and if you do not willingly create a prejudice, nobody can ever put you on stand. And quite the other way, in fact, there is an obligation for the people themselves by common law. It's not a government obligation, it's a moral and conscience obligation to in fact judge other people if they have done wrong. But not only that, how about we judge people for the right that they've done one day? Just realized that the microphone was well in the way. It doesn't matter. Not doing that for you to look at me. But yeah, how about we one day, it's just a wish, it's of no consequences, instead of doing only wrongdoing trials, how about we start doing trials for right doing? I mean, there are some people that probably deserve more than what they have based upon the action that they've done in this society. Just as an example, if a firefighter just rushed into a fire and saved a baby and 2 cats which were about to burn, this guy's a hero, or this girl's a hero. All the people that are doing search and rescue for the Coast Guard, we never get to hear about them in the stupid newspaper because they're controlled by the same bastard who pretend that they are our leaders. But those are just examples. I don't want this to be too long today. It's already been long enough. Once again, after over an hour of reading, I'm dry. Got my mouth so dry that I shouldn't be drinking coffee. I should be drinking water. But yeah, I'll let that sink into you. I'll put a note or a comment as to where I am, if I can figure out how to do add sticky notes. So here's a sticky note and a note. I'm gonna post it. Before I save it, I'm just going to quickly check on this document here, how long I still have for this chapter. The next recording may be short, depending. I don't know how much I still have. There's a few pages. Yeah. Oh yeah, one other thing that I thought while reading it, you have noticed in the text that there's a difference between London and Westminster. London is a commercial entity which is not part of the United Kingdom, which is a 2 square mile city in the middle of the city that we like to call London, but really is Westminster. That's the capital city of England. London is where the Bank of England is, and like I just said a moment ago, it's not part of England, so it's all a scam. It's a commercial scam. We must put an end to this scam upon the people. I'm not saying that we can go without law for corporation. All these laws are for corporation, and we should hold them accountable to all this mess that they've made. Remember one thing, for you, the people, the humans, the living creatures, only one law, so simple it's mind-boggling: do no harm. And that's it. The rest does not concern you, nor me. And anyone who tried in the past to put all these laws on my back, they only got one answer. It's 2 words. It's in French mainly, va chier, or in English, fuck you. And that's it. It should be the same for you, because if you're not free to tell someone else to go fuck themselves, you're not free at all. unless they really have a claim upon you, then he's going to be the one to tell you to go fuck yourself. So do no harm should get you in life without ever having to stand trial, you as the accused or the defendant, but you could be the claimant, or more important, you could be the juror, and you have the freedom to void or to render null and void the so-called power of government, because they had none. They never had any, or very, very little, or so little that anybody could challenge them. Basically, the only power government ever had was to shut their fucking mouth and obey the people, or else. Else what? Well, it's not my opinion, once again, it's history, so there's no threat to anyone. They've put their own government on trial, and they've put them back into their place, even to the extent of going to war against it. Yes, it's not my opinion. These are facts. So if you're a member of the government today and you've taken part into a legislation that is tyrannic in nature, if I were you, I'd find a hole to hide in. And that's all there is to it. As for one, when I got my orders from the grand jury, I was getting orders from the people that nobody ever challenged in 5 years, and nobody ever will, because they're the will of the people. And if you had time to listen to the case that was presented or the cases, because there were 7 of them, presented in front of the grand jury, you probably would have done the same as that grand jury did. There was an unanimous decision at the end. And once again, I was yelling at them to prove me wrong and to tell me to go fuck myself. They did not. They were yelling back at me to get on with it and listen to what they had to say, what their decision was. And here I am, 5 years later. It's still true. It still was the right thing to do. And I hope, even though I have no hope for this society, that you will do as a human what's right, as opposition as what's wrong. Start organizing court, real court, not government, clown kangaroo court. Be a human of conscience, of duty, of understanding. Because if I'm the only one trying to do that, well, I'll be the only one. And I do not wish to impose anything upon people, as I don't want anything imposed on me. That's all there is to it today. 1 hour, 40 minutes, that's enough, and that's enough ranting. So, yeah, I'm gonna go do something else. Maybe there may be a gap between this recording and the next one. There may be no next one. I don't know. Because in the end, there's no real need to read all of this. We've got the most important part of it. Urge you to be free. Have a nice day.